Hi guys, welcome back to my channel. So today in this video I will continue the previous video entitled Maritime Liens in the United States. Providing the necessaries must be provided by the vessel by the person claiming a maritime lien under the CAMLA. While this requirement may be simply stated, difficulties often arise satisfying this requirement. In some instances, the person claiming the maritime lien may not have physically provided the necessary, but may have merely arranged for the provisions of necessaries. Under United States law, a party need not be the physical supplier or deliverer to have provided necessaries within the meaning of CIMLA and remain eligible for a maritime lien. However, particular attention is needed in these circumstances to ascertain the precise contractual arrangement between all parties involved in these provisions of necessaries, including any and all intermediary trades and or brokers. This is crucial to ascertain the manner in which all parties involved and the provisions were originally written, how they were compensated and or derive a profit, and perhaps most importantly, whether payment has been made by the person claiming a maritime lien. This analysis is important to ensure that the person claiming the maritime lien is, in fact, providing the necessaries to the vessel as contemplated by CIMLA. Another difficulty arises due to the fact that maritime liens are freely assignable under United States law. Accordingly, particular attention is needed to determine whether the person claiming the maritime lien actually provided the necessaries to the vessel, whether the party from whom they may have taken an assignment of the maritime lien actually provided the necessaries to the vessel. Necessaries is defined in CIMLA to include repairs, supplies, stowage, and the use of a dry dock or marine railway. In addition, necessaries has been broadly interpreted under United States law to mean any goods or service that are useful to the vessel, keep her out of danger, and enable her to perform her particular function. Example of valid necessaries include stewarding service, pilot age services, provisions for crew and passengers, buffet and dockage, towage, advertising, and of course bunker and lubricating oil. On the order of the owner or person authorized by the owner. Section 31341A of CIMLA provides that the following persons are presumed to have authority to procure necessaries for a vessel. 1. The owner. 2. The master. 3. A person entrusted with the management of the vessel at the port of supply. 4. An officer or agent appointed by the owner. A. The owner. B. The charterer. C. The owner provides, or D. An acquit buyer in possession of the vessel. As is evident from the clear language section 31341A of CIMLA, various persons, include a charterer, are presumed to have authority to order such necessaries and thus bind the vessel in rem through the creations of a maritime lien. Notwithstanding sections 31341A of CIMLA, These general presumptions of authority can be rebutted if there is evidence that a supplies of necessaries had actual or constructive notice of relevant person, including a charterer's inability to create a liens on the vessel. While the burden of proof on owners to rebut these presumptions is a heavy one, owners usually rely upon prohibitions of lien clauses in two circumstances. First, it is common for owner to attempt to prelude a charterer from having actual authority to incur any maritime liens against the vessel by inserting a prohibition of lien clause commonly prior to a non-lien clause in the charter party. Such clauses are valid and enforceable as between owners and charterers. Furthermore, such clauses will be effective against supplier of necessaries, but only if they have actual knowledge of the clause at or before the time the necessaries are provided to the vessel. Thus, for example, to prevent a bunker supplies engaged by a time charterer from obtaining a maritime lien against the vessel for the value of the bunkers, notice of the prohibitions of lien clause in the charter party must be provided to the physical supplier before the bunker are pumped on board the vessel. Notice of the prohibitions of lien clause given after the bunkers are pumped on board will be ineffective to prevent a maritime lien arising. Second, it is common practice to stamp a prohibitions of lien clause of the bunker delivery receipt. However, the stamp of a bunker delivery receipt with a notice of the prohibitions of lien clause will only be effective if it is done before the bunkers are pumped on board on the vessel. Enforcement. Rule C of the Supplemental Rules for Admiralty or Maritime Claims and Assets Forfeiture Actions under the Federal Rules of Civil Procedure provide the mechanism by which maritime liens can be enforced against vessel and or other maritime property. Rule C arrest can be united utilized to either A. Acquire jurisdictions over a defendant, B. Seize property to obtain security for a claim, and or C. Seize property in connection with the enforcement of a judgment. Rule C is an rem arrested on a vessel or other maritime property which is brought directly against the vessel. A Rule C in rem actions may be brought only by plaintiff who possesses a maritime lien, and thus the in rem possess may be asserted only against the specific property that is subject of the maritime lien. Priorities. Should it be necessary to enforce maritime liens and or reverse ship mortgage against maritime property through a judicial sale, that is predetermined priority of claims under the United States law. Determining the priorities to any sale proceed involves a two-step process, ranking and classify the different classes to liens and or mortgage, and determining what claims come first within each class. With respect to ranking classes of claims, the following order is adopted. 1. Expenses of justice incurred during an arrest. 2. Master and crew wage liens. 3. Salvage and general average liens. 4. Tort liens, including personal injuries and death. 5. Mortgage, pre-mortgage statutory maritime liens for necessaries. 6. Preferred ship mortgage liens. 7. Statutory maritime liens for necessaries. 8. State law created maritime liens. 9. Liens for violating or federal statutes. 10. Preferred non-maritime liens, including tax liens. And 11. Attachment liens. And then the 12 maritime liens in bankruptcy. So that's all the article. Bye bye and see you on my next video. Bye.